Hello there. Welcome to Sumit Academy. I do hope that you have subscribed to my channel. Do subscribe now so that you do not miss out on my previous or future videos. In this video, the second of our two-part series on money laundering, we shall first talk about the effects of money laundering. The first of such effects is called social effects. Successful money laundering means that criminal activity does actually pay off. This success encourages criminals to continue their illicit schemes because they get to spend the profit with no repercussions. This means more fraud, more corporate embezzling, more drugs on the streets, more drug-related crimes, law enforcement resources stretched beyond their means, and a general loss of morale on the part of legitimate business people who do not break the law and do not make as much profits as the criminals do. Next are the economic effects. Developing countries often bear the brunt of money laundering because the governments are still in the process of establishing regulations for their newly privatized sectors. Other major issues facing the world's economies include errors in economic policy resulting from artificially inflated financial sectors, massive influx of dirty cash into particular areas of the economy that are desirable to money launderers, create false demand, and officials act on this false demand by adjusting economic policies. When the laundering processes reach a certain point, or if law enforcement officials start to show interest, all that money suddenly disappears without any predictable economic cause, and that financial sector falls apart. We now move on to anti-money laundering measures in India. As a developing nation, India feels seriously concerned not only because money laundering, including hawala transactions, have been threatening the economy, but also because such practices contribute to the country's illicit drug trafficking and terrorist and subversive activities. India is becoming a transit point for drug traffickers and other criminals from the Golden Crescent, which is Pakistan, Afghanistan, and Iran, and the Golden Triangle, that is Myanmar, Thailand, and Laos. Before the enactment of Prevention of Money Laundering Act 2002, the major statutes that incorporated measures to address the problem of money laundering were the Income Tax Act 1961, the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, otherwise known as Coffee Posa, the Smugglers and Foreign Exchange Manipulators Act 1976, the Narcotic Drugs and Psychotropic Substances Act 1985, the Benami Transactions Prohibition Act 1988, the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988, and the Foreign Exchange Management Act 2000, known as FEMA. In 2002, Parliament passed the Prevention of Money Laundering Act. The main objectives of this act are to prevent money laundering as well as provide for confiscation of property, either derived from or involved in money laundering. Banks and other financial institutions and intermediaries have to maintain records that detail the nature and value of transactions, whether such transactions comprise a single transaction or a series of connected transactions, and where these transactions take place within a month. Under Section 468 of the CRPC, there is no limitation period for offences punishable with imprisonment of more than 3 years. Hence, for offences punishable under the PMLA, there is no limitation period. ED, therefore, can initiate a prosecution for an offence of money laundering after any number of years. Many amendments have been made into the PMLA Act in the last few years to make it more stringent. In 2013, the monetary threshold was done away with. In 2015, the definition of proceeds of crime was expanded to enable the Directorate to attach equivalent value of property in India of the accused if the accused has moved the POCs out of India. With all these measures in place, the question arises as to why no one has gone to jail for money laundering. The Indian Prosecution Network for Anti-Money Laundering has all the elements in place except the criminal. In 12 years since July 2005, when the Enforcement Directorate was asked to operate the Prevention of Money Laundering Act, only a handful have been convicted for the crime. India's lead prosecuting agencies against money laundering and illegal use of foreign exchange has tried hard, but it has not managed to crack through a stretched out judicial process. The lack of interagency coordination among the prosecution agencies and a crippling shortage of staff. It has managed to sniff out over rupees 9,000 crores as suspected haul from money laundering in a decade. But it has yet to link those against anyone successfully in a court. The number seems impressive, but judge against the estimates put out by the Financial Action Task Force, the lead international tracking agency for this crime, it is peanuts. FATF estimates the money being laundered at over 2% of the GDP of its member countries, or about rupees 120,000 crores for India. The Enforcement Directorate has two laws under which it prosecutes offenders. Of them, the Foreign Exchange Management Act carries no criminal liability. It is more of a relic of the older Foreign Exchange Regulation Act that was framed at a time when India used to suffer massive shortages of foreign exchange. Now, it is the Prevention of Money Laundering Act through which the ED mostly enforces its mandate now. The passage of the Act was India's passport to join the 37-country FATF in 2010, the last country allowed to do so to date. The Act has a long list of 28 types of offences that are treated as crime, including those of willful pollution and trade in wildlife. To turn the heat on such crimes, Parliament has had to amend several acts to bring them in sync with the tough regime. The problem emerges in making the charges stick. Though they are quite successful in collecting evidence of wrongdoing from the records of financial agencies in India, but they are stymied in gathering those from abroad. Most money laundering cases have a foreign link to them. In the case of businessman Vijay Mallya, for instance, the ED is convinced there is a valid PMLA offence. While reneging on a bank loan is not an offence under PMLA, escaping a country consequently is. The Directorate has consequently asked the Interpol to help arrest Mallya for deportation to India. Even though India has won all the court cases in the United Kingdom against Mallya, he is still to be deported. This is a tough call. A money laundering charge has to be agreed upon as one both within India and abroad. If a court abroad decides the case can be settled with a rap on the knuckles and lets go of the defendant, any case made out in India too falls apart. The special courts here have to release the wealth of the person here. It is a provision that India has objected to since 2011. But negotiations in the Inter-Country Forum, the FATF, are yet to provide results. In the absence of convictions, the ED has found itself more often in the news for taking up high-profile cases like that of Mallya. But the charge sheets have to be brought in simultaneously at the same designated courts. Under PMLA, the ED cannot produce the primary charge sheet. It is for the others, like the income tax or the CBI, to make out the first case. Indian investigating agencies don't like to share information on cases, so the charge sheets suffer. Statistics show that ED has managed to prosecute only 173 people in 11 years. Tracking a money laundering case is a complex exercise. The ramifications of the cases go deep and cannot be classified only as white-collar crimes. It also requires a high-level political commitment to ensure that the legal, regulatory, and operational reforms required by the action plan are implemented, as FATF puts it. In its absence, the records of most countries to bring a money laundering case to completion is dismal, which is why the organization is keen to pounce upon even a single successful prosecution anywhere as a major achievement. ED depends on the mass of data supplied by the Financial Intelligence Unit, which tracks banks and others for suspected layering of transactions. The Offenders Tracking System, EDOT, and National Risk Assessment Monitoring System trails the stages at which the crime lies. The stock market, with its lightning-fast trade regime, is an attractive destination for the launderers, just as stacking up bank transactions just below the threshold for automatic detection. The lack of personnel had the agency struggling to deal with the disclosures surrounding allocation of mines for favors in Jharkhand in 2012. The money trail forced the Election Commission to ask for re-elections to the Rajya Sabha seats from the state. The courts haven't helped by passing contradictory orders, keeping up the good times for the suspected criminals. India has taken up various anti-money laundering measures to curb with this issue. But these measures, somewhere or the other, have some loopholes or lacunas and thus is not fulfilling their complete purpose. Some of such problems are, firstly, growth of technology. With the advent of technology at such a great speed, it has been possible for the money launderers to act on obscuring the origin of proceeds of crime by cyber finance techniques. The enforcement agencies are not able to match up with the speed of growing technologies. Secondly, there is a lack of awareness about the problem. The issue of money laundering is growing at a very high pace. Its unawareness among the common public is an impediment for implementation of proper anti-money laundering measures. The poor and illiterate people, instead of going through lengthy paperwork transactions in banks, prefer the Hawala system where there are fewer complexities and formalities, little or no documentation, lower rates, and they also provide security and anonymity. This is mainly because such people don't know the seriousness of this crime and are not aware of its harmful after effects. Thirdly, non-fulfillment of the purpose of KYC norms. RBI has issued the policy of KYC norms with the objective to prevent banks from being used by criminals for money laundering or terrorist financing activities. However, it does not cease or abstain from the problem of Hawala transactions, as RBI cannot regulate them. Further, such norms are only a mockery as the implementing agencies are indifferent to it. Also, the increasing competition in the market is forcing the banks to lower their guards, thus facilitating the money launderers to make illicit use of it in furtherance of their crime. Fourthly, there is widespread smuggling. There are a number of black market channels in India for the purpose of selling goods, offering many imported consumer goods such as food items, electronics, etc., which are routinely sold. The black merchants deal in cash transactions and avoid customs duties, thus offering better prices than the regular merchants. After liberalization of government, though this problem has been lessened, but it has not been done away with completely and still poses a threat to the nation's economy. The fifth problem is the lack of comprehensive enforcement agencies. The offense of money laundering is no more stuck to one area of operation, but has expanded its scope to include many different areas of operation. In India, there are separate wings of law enforcement agencies dealing with money laundering, cyber crimes, terrorist crimes, economic offences, etc. Such agencies lack convergence amongst themselves. The issue of money laundering, as we have seen, is a borderless world, but these agencies are still stuck with the laws and procedures of the states. Combating the offense of money laundering is a dynamic process, since the criminals involved in it are continuously looking for new ways to achieve their illicit motives. Moreover, since various countries are entering into multiple agreements and conventions in order to strengthen their measures to combat money laundering, the money launderers are targeting and exploiting those jurisdictions which are weak and do not have sufficient laws to deal with such an offense. Money laundering involves activities that are international in nature. Therefore, to make an impact, it is necessary that all countries should enact strict and as far as possible similar laws so that the money launderers will have no place to launder their proceeds of crime by way of weakness of jurisdiction. Since the states have no obligation in deciding which offences should be considered as predicate offences to money laundering, there is no consensus in the international harmonizing efforts for anti-money laundering. Thus, there is a need to enlist common predicate offences to solve the problem internationally, particularly keeping in mind the transnational character of the offense of money laundering. Furthermore, the provision of financial confidentiality in other countries is an issue. The states are unwilling in compromising with this confidentiality. There is a need to draw a line between such financial confidentiality rules and these financial institutions becoming money laundering havens. Apart from that, many people are of the opinion that money laundering is a victimless crime. They are unaware of the harmful effects of such a crime to the national economy. So there is a need to educate such people and create awareness among them and infuse a sense of watchfulness towards the instances of money laundering. This would also help in better law enforcement as it would be subject to public examination. Finally, to have effective anti-money laundering measures, there needs to be a proper coordination between the center and the state. For that, the tussle between the two should be removed. The laws should not only be the responsibility of the center, but it should be implemented at the state level too. The more decentralized the law would be, the better reach it will have. Therefore, to have an effective anti-money laundering regime, one has to think regionally, nationally, and globally. Well, that's all from me in this video. This video is based on the information freely available on the internet. No originality is claimed for the same. I express my gratitude to all the media and legal websites for the information carried by them. The intention of this video is to prepare candidates for answering examination questions on the subject. Do like this video and do subscribe to my channel so that you do not miss out on my previous or future videos. Till later then, cheerio.